The House of Lords Constitutional Committee hearing room fell into stunned silence as Baroness Hale of Richmond slowly removed her reading glasses and fixed her steely gaze directly on Home Secretary Suella Braverman. The atmosphere shifted dramatically when Lady Hale's calm, authoritative voice cut through the tension. "Home Secretary, I'm afraid your understanding of constitutional law appears to be fundamentally flawed." Braverman, who had been aggressively defending her controversial immigration policies for the past hour, suddenly looked like she had been slapped. The woman who had built her political career on legal arguments was about to face the most devastating constitutional law lesson of her life, delivered by the former President of the Supreme Court, who had shaped British jurisprudence for decades. What happened in the next 45 seconds would leave Braverman completely speechless and expose the shocking gaps in her legal knowledge despite her position as the nation's chief law officer. Lady Hale had been sitting quietly, taking notes, with surgical precision, while Braverman made one constitutional error after another. Now Britain's most distinguished female judge was about to systematically dismantle every argument with the kind of legal brilliance that makes constitutional scholars weep with admiration. This wasn't going to be a political debate between conservatives and liberals. This was about to become a masterclass in how genuine constitutional expertise destroys amateur legal theatre with nothing but precedent, principle, and decades of judicial wisdom. Before we witness this incredible moment where constitutional mastery met political opportunism, make sure to hit that subscribe button and ring the notification bell so you never miss these explosive confrontations where legal brilliance triumphs over political rhetoric. Now let's see how Lady Hale delivered one of the most devastating intellectual demolitions in British political history. To understand why this confrontation was so extraordinary, you need to know the remarkable backgrounds of these two powerful women and what brought them to this historic clash that would define their legacies in British legal and political history. Baroness Hale of Richmond represents the absolute pinnacle of British legal achievement. At 78 years old, Lady Hale served as President of the Supreme Court from 2017 to 2020, becoming the most senior female judge in British history. But her appointment wasn't symbolic. It recognized one of the most brilliant legal minds of her generation. She graduated from Cambridge University with a starred First in Law, becoming the first woman to achieve this distinction. She was called to the bar in 1969, became a Queen's Counsel in 1989, and was appointed to the High Court in 1994. Lady Hale's judicial career spans over 5 decades of groundbreaking legal work. She served on the House of Lords as a law lord from 2004 and became a founding member of the Supreme Court in 2009. Her judgments have shaped family law, human rights law, and constitutional law in ways that continue to influence British jurisprudence today. She's known throughout the legal world for her razor-sharp intellect, her ability to cut through complex legal arguments with surgical precision, and her unwavering commitment to constitutional principles. But Lady Hale's influence extends far beyond her judicial decisions. She's a legal scholar who has written extensively on constitutional law, a pioneer who broke gender barriers throughout her career, and a judicial stateswoman whose opinions are studied in law schools across the Commonwealth. When Lady Hale speaks about constitutional law, the entire legal establishment listens. Her judicial philosophy is grounded in rigorous constitutional analysis, deep respect for legal precedent, and an understanding that the law must serve justice while maintaining constitutional balance. She doesn't engage in political theatre or partisan arguments. She lets constitutional principles and legal reasoning speak for themselves. On the other side sat Suella Braverman, the 43-year-old Home Secretary who has positioned herself as one of the most hardline conservative politicians in Britain. Braverman studied law at Cambridge University and qualified as a barrister, specializing in planning and judicial review law before entering politics. She served as Attorney General from 2020 to 2022, before becoming Home Secretary under Liz Truss and then Rishi Sunak. Braverman has built her political career on aggressive conservative positions, particularly regarding immigration, human rights, and constitutional issues. She's become the face of the Conservative Party's most controversial policies, from the Rwanda deportation scheme to attempts to withdraw from the European Convention on Human Rights. Her supporters see her as a principled conservative willing to challenge liberal legal orthodoxy, while her critics view her as someone who uses legal-sounding arguments to justify politically motivated policies. But Braverman's legal background, while impressive to general audiences, pales in comparison to Lady Hale's constitutional expertise. Her practice focused on planning law and administrative matters rather than the high-level constitutional law that Lady Hale has mastered over decades. More importantly, Braverman's transition into politics has meant that her legal arguments often serve political goals rather than pure legal analysis. The confrontation took place during a House of Lords Constitutional Committee hearing on the future of human rights law in Britain, a hearing that was supposed to examine the government's proposals to reform human rights legislation. Lady Hale had been invited as a constitutional expert to discuss the legal implications of proposed changes, while Braverman was there to defend the government's position. The hearing was chaired by Lord Hope of Craighead, another former Supreme Court Justice, who had specifically requested that the discussion focus on constitutional principles rather than partisan politics. The committee included some of Britain's most distinguished legal minds, all of whom were expecting a serious discussion about constitutional law rather than political grandstanding. But Braverman had different plans. She saw the hearing as an opportunity to defend her controversial policies and attack what she called the liberal legal establishment that had consistently challenged government policies in court. What she didn't anticipate was that Lady Hale would be prepared to defend not just legal principles, but to expose the fundamental flaws in Braverman's constitutional reasoning. The stakes couldn't have been higher for both women. For Lady Hale, this was an opportunity to defend constitutional principles that she had spent her career developing and protecting. Her reputation as Britain's foremost constitutional expert was built on decades of rigorous legal analysis, and she wasn't going to let political expedience undermine constitutional foundations. For Braverman, this was a chance to establish her credentials as a serious legal thinker rather than just a political attack dog. She had been criticized throughout her career for prioritizing political outcomes over legal principles, and this hearing offered an opportunity to demonstrate genuine legal expertise rather than partisan rhetoric. Lady Hale's approach to the hearing reflected her judicial temperament and scholarly background. She came prepared with extensive research on constitutional precedents, detailed knowledge of relevant case law, and a clear understanding of the historical development of British constitutional principles. She wasn't there to score political points or generate headlines, but to engage in serious constitutional discourse. Braverman's approach was fundamentally different. She came armed with political talking points designed to appeal to conservative voters and media outlets. Her strategy was to attack the liberal legal establishment and defend government policies, using legal-sounding arguments that would resonate with Conservative Party supporters. The fundamental mismatch between Lady Hale's scholarly approach and Braverman's political strategy would become apparent within minutes of the hearing beginning. While Lady Hale was prepared to discuss the finer points of constitutional interpretation and judicial precedent, Braverman was ready to wage political warfare using constitutional law as a weapon. The hearing format initially seemed to favor Braverman. As a serving government minister, she was comfortable with the political aspects of parliamentary hearings. She knew how to project authority, how to make arguments that sounded convincing to general audiences, and how to deflect criticism while staying on message. But format advantages mean nothing when facing someone with Lady Hale's level of constitutional expertise. The former Supreme Court president had spent her entire career preparing for exactly this kind of intellectual combat, and she was about to demonstrate why there are levels to constitutional knowledge that political figures simply cannot reach. What made the confrontation even more significant was the broader context of constitutional debate in modern Britain. Conservative politicians had been attacking the judiciary and human rights law for years, claiming that activist judges were undermining democratic decision-making and that human rights legislation was being used to frustrate legitimate government policies. Braverman represented this school of conservative constitutional criticism. The idea that judges had overstepped their constitutional role, and that human rights law needed to be reformed or abandoned to restore parliamentary sovereignty. It was a narrative that had gained traction among Conservative Party members and right-wing media outlets. Lady Hale had remained largely above these political attacks during her tenure on the Supreme Court, as judicial propriety required. But this hearing provided an opportunity for her to address these criticisms directly and demonstrate the importance of constitutional principles that politicians seemed eager to abandon for short-term political gain. The irony was that Braverman's attacks on constitutional principles would end up highlighting the vast difference between genuine constitutional expertise and political rhetoric dressed up as legal argument. By challenging Lady Hale on constitutional law, Braverman was entering a battlefield where she was completely outmatched intellectually. The hearing had begun formally, with Lord Hope delivering opening remarks about the importance of constitutional dialogue and the need for careful consideration of proposed changes to human rights law. Lady Hale had given a measured opening statement about the historical development of constitutional principles and the importance of maintaining judicial independence in a democratic society. When Braverman's turn came to present the government's position, she immediately shifted the tone from academic discussion to political combat. "Baroness Hale," she began, her voice carrying the prosecutorial edge that had made her a favorite among Conservative Party activists. "I think it's time we had an honest conversation about how judicial activism has undermined democratic governance in this country." The room tensed as it became clear that Braverman wasn't interested in the kind of scholarly constitutional discussion that Lord Hope had envisioned. She was here to wage political warfare against the judiciary, using the formal setting of a Lords' Committee to legitimize what amounted to a sustained attack on judicial independence. Lady Hale remained perfectly composed, her expression neutral as she listened to Braverman's opening salvo. Decades of judicial experience had taught her to maintain emotional control, regardless of the nature of attacks being directed at the judiciary or constitutional principles she had spent her career defending. The Supreme Court's decision in Miller, too, was a clear example of judicial overreach, Braverman continued, referring to the landmark case where the Supreme Court ruled that Boris Johnson's prorogation of Parliament was unlawful. The court substituted its own political judgment for that of elected officials, fundamentally undermining parliamentary sovereignty. The attack was designed to put Lady Hale on the defensive about one of the most significant constitutional decisions of her career as Supreme Court President. It was a classic political tactic. Take a complex constitutional decision and reduce it to a simple narrative about unelected judges overruling democratic decisions. But Braverman had made a strategic error. She had chosen to attack Lady Hale on a case that perfectly demonstrated the Supreme Court's commitment to constitutional principles and the rule of law. Moreover, she had mischaracterized the legal issues involved in a way that would allow Lady Hale to not just defend the decision, but to expose Braverman's fundamental misunderstanding of constitutional law. Lady Hale listened patiently as Braverman continued her attack, making careful notes on her legal pad. She wasn't preparing a political response. She was documenting every constitutional error and legal misstatement that Braverman was making. Furthermore, Braverman pressed on, the Human Rights Act has been used repeatedly to frustrate legitimate government policies, from immigration enforcement to national security measures. These judicial interventions represent a fundamental challenge to parliamentary democracy. The accusation was serious, essentially arguing that human rights protections were incompatible with democratic governance. It was the kind of argument that had become popular among conservative politicians who found legal constraints inconvenient for their policy objectives. But again, Braverman was making constitutional claims that she couldn't support with serious legal analysis. She was relying on political talking points rather than constitutional scholarship, and she was about to discover that Lady Hale wasn't going to let those claims go unchallenged. As Braverman continued her presentation, it became increasingly clear to the constitutional experts in the room that she was out of her depth. Her characterizations of judicial decisions were superficial and politically motivated. Her understanding of constitutional doctrine was flawed, and her legal reasoning contained errors that any competent constitutional lawyer would immediately recognize. The Rwanda policy is a perfect example, Braverman said, moving to one of her signature issues. The courts have blocked this legitimate government policy based on expansive interpretations of human rights law that go far beyond what Parliament intended when it passed the Human Rights Act. Lady Hale's eyebrows raised slightly, the first sign of reaction she had shown during Braverman's lengthy presentation. Constitutional experts in the room immediately understood why. Braverman had just made a claim about parliamentary intention that was demonstrably false and easily refuted by reference to legislative history and parliamentary debates. The claim suggested either that Braverman hadn't actually researched the parliamentary debates surrounding the Human Rights Act, or that she was deliberately misrepresenting parliamentary intention for political purposes. Either possibility was professionally embarrassing for someone serving as the government's chief legal officer. But Braverman continued with her prepared presentation, apparently unaware that she had just exposed significant gaps in her constitutional knowledge. We need to restore the proper constitutional balance by limiting judicial review and reforming human rights law to reflect democratic priorities rather than judicial preferences. The argument was fundamentally flawed because it misunderstood the basic structure of constitutional democracy. The separation of powers requires judicial review precisely to maintain constitutional balance, not to undermine it. Braverman was essentially arguing for the elimination of constitutional checks and balances while claiming to defend constitutional principles. Legal experts in the audience exchanged worried glances. Constitutional law is not a political game,
where arguments can be made without regard to legal precedent and constitutional principle. Making fundamental errors while attacking the constitutional foundations of British democracy was like trying to perform brain surgery with garden tools. The
pattern is clear, Braverman concluded with apparent satisfaction. Judicial activism has consistently undermined democratic decision-making, and it's time to restore parliamentary sovereignty by limiting judicial interference with legitimate government policies. The accusation hung in the air as Braverman finished her remarks and sat back with the confident expression of someone who believed she had just delivered a devastating critique of the British constitutional system. She had no idea that she had actually provided Lady Hale with the perfect opportunity to demonstrate the difference between serious constitutional scholarship and political rhetoric dressed up as legal argument. Lady Hale had filled several pages with notes during Braverman's presentation, but she wasn't taking notes on how to defend herself or the judiciary. She was documenting every constitutional error, every factual mistake, and every mischaracterization that Braverman had made. She was building a case that would not just refute Braverman's arguments, but would expose the fundamental weakness of her constitutional reasoning. The room was silent as everyone waited to see how Lady Hale would respond. Would she take the diplomatic approach and avoid direct confrontation with a serving government minister? Would she engage in the kind of political sparring that Braverman was clearly hoping for? Or would she do something else entirely? Lady Hale slowly put down her pen, looked directly at Braverman with the calm authority that had made her one of the most respected judges in the Commonwealth, and began to speak in the measured tone that had become her trademark during Supreme. "Court hearings, Home Secretary," she said, her voice carrying the weight of decades of constitutional expertise. "I'm afraid your understanding of constitutional law appears to be fundamentally flawed." Lady Hale's response began with the kind of surgical precision that had made her legendary among constitutional lawyers. "Home Secretary, let me address your characterization of Miller too, since you've raised it as an example of judicial overreach. The Supreme Court in that case was not making a political judgment. We were applying well-established constitutional principles about the relationship between Parliament and the executive." Her voice remained calm and measured, but every word carried the authority of someone who had not only decided the case, but understood its constitutional foundations better than anyone else in the room. The principle that the executive cannot act to frustrate or prevent Parliament from carrying out its constitutional functions is not judicial activism. It's a fundamental principle of our constitutional democracy that dates back centuries. The legal experts in the room immediately recognized the devastating precision of Lady Hale's response. She wasn't defending a political decision. She was explaining constitutional doctrine with the kind of clarity that only comes from decades of judicial experience and scholarly study. But Lady Hale was just getting started. You've suggested that this decision undermined parliamentary sovereignty, but that fundamentally misunderstands what parliamentary sovereignty means in constitutional terms. Parliamentary sovereignty requires that Parliament be able to function. It cannot be sovereignty if the executive can simply shut Parliament down to avoid scrutiny. The constitutional logic was unassailable. Lady Hale was demonstrating that, far from undermining parliamentary sovereignty, the Miller II decision had actually protected it from executive interference. Braverman's attack had been based on a complete misunderstanding of constitutional principles. Lady Hale pulled out a thick legal brief and opened it to a marked page. Since you've questioned the constitutional foundations of our decision, let me read directly from the judgment to clarify the legal reasoning involved. She began reading from the Miller II judgment in clear, precise language that demonstrated not just her mastery of constitutional law, but her ability to write complex legal analysis with remarkable clarity. The contrast with Braverman's confused and politically motivated characterizations was stark and undeniable. As the court stated, Lady Hale continued after reading the relevant passage, the power to prorogue Parliament is not absolute. It is constrained by constitutional principles, including the principle that Parliament must be able to carry out its constitutional functions. This isn't judicial activism. It's the application of constitutional law that has developed over centuries. The legal reasoning was so clear and well-grounded in constitutional precedent that even non-lawyers in the room could understand that the Supreme Court had been applying established constitutional principles rather than making up new law as Braverman had claimed. Lady Hale then turned to Braverman's broader attack on judicial review and human rights law. Home Secretary, you've argued that judicial review and human rights protections undermine democratic governance. Could you explain how protecting constitutional rights and ensuring government operates within the law undermines rather than supports democracy? It was a brilliant tactical question that exposed the fundamental flaw in Braverman's argument. Lady Hale was asking Braverman to explain how constitutional protections that prevent government overreach could be incompatible with democratic governance, a position that was constitutionally indefensible. Braverman stammered for a moment before responding. Well, when unelected judges overturn decisions made by elected officials, that clearly undermines democratic accountability. Lady Hale interrupted gently but firmly. Home Secretary, that description misunderstands the role of judicial review in our constitutional system. Courts don't overturn government decisions because they disagree with them politically. They review whether government has acted within the law and within constitutional constraints. The distinction was crucial and exposed Braverman's fundamental misunderstanding of judicial review. Lady Hale was explaining that judicial review exists precisely to support democratic governance by ensuring that government operates within constitutional limits. Could you give me a specific example of a case where you believe the courts applied the Human Rights Act in a way that went beyond parliamentary intention? Lady Hale asked, pulling out another legal brief. I have the parliamentary debates from the passage of the Human Rights Act here, and I'd be interested to know which specific interpretations you find problematic. The question was devastating because it demanded that Braverman demonstrate actual knowledge of parliamentary debates and legal interpretation rather than relying on political talking points. Lady Hale was asking for the kind of detailed constitutional analysis that judges perform routinely, but that politicians often avoid. Braverman shuffled through her papers desperately, clearly unprepared for Lady Hale's demand for specific constitutional analysis. Well, there have been numerous cases where the interpretation of Article 8 rights has frustrated deportation policies. Could you be more specific? Lady Hale pressed. Which cases and what specific aspects of the legal reasoning Do you find constitutionally problematic? Lady Hale was now operating in full Supreme Court justice mode, conducting the kind of rigorous constitutional examination that exposes inadequate legal arguments. She was asking Braverman to engage in the kind of detailed constitutional analysis that Lady Hale performed daily, but that Braverman was clearly not prepared to handle. The former Supreme Court president pulled out one final document that would deliver the knockout punch. Home Secretary, since you've raised the Rwanda policy, I think we should examine the constitutional issues involved. This is the Court of Appeal's judgment in the Rwanda case. Have you read the full judgment? Braverman looked uncomfortable. I'm familiar with the decision, obviously. Then you'll know that the Court of Appeal didn't base its decision on expansive interpretations of human rights law, as you've claimed. The court found that the policy violated specific statutory protections that Parliament had explicitly enacted. The court was applying parliamentary will, not frustrating it. The correction was devastating because it showed that Braverman had either not read the judgment she was criticizing or had deliberately misrepresented its legal reasoning. Either possibility was professionally embarrassing for the Home Secretary. Lady Hale continued with surgical precision. The Court of Appeal specifically found that the Rwanda policy violated the Immigration and Asylum Act 1999, legislation passed by Parliament to establish statutory protections for asylum seekers. The court was enforcing parliamentary will, not overriding it. The legal analysis was crushing to Braverman's political narrative. Lady Hale was demonstrating that the courts had actually been protecting parliamentary legislation against executive action that violated statutory protections. Home Secretary, Lady Hale said, looking directly at Braverman with the calm authority of constitutional expertise. You've made several claims about judicial overreach and constitutional principles, but your arguments appear to be based on misunderstandings of both judicial decisions and constitutional law. The room was completely silent. Braverman sat there looking like she had just received a constitutional law tutorial from the most distinguished judge in British history, while Lady Hale maintained the composed demeanor of someone who had simply corrected a few factual errors, rather than delivered one of the most devastating intellectual demolitions in parliamentary history. Lady Hale's systematic dismantling of Braverman's arguments had been so thorough and so intellectually devastating that there was literally nothing Braverman could say in response. Every constitutional claim had been refuted, every legal argument demolished, and every factual assertion corrected. Do you have any specific constitutional questions about judicial review or human rights law that I can address with reference to actual legal precedent and constitutional principle? Lady Hale asked, giving Braverman one final opportunity to engage in serious constitutional discourse rather than political theater. Braverman shook her head, clearly recognizing that any further attempts to challenge Lady Hale would only result in more professional humiliation. The Home Secretary, who had built her career on attacking the judiciary, had been reduced to silence by someone who simply understood constitutional law better than she did. The explosion that followed Lady Hale's systematic destruction of Suella Braverman was unlike anything the British legal and political establishment had witnessed in decades. Within minutes of the hearing ending, Baron Hale destroys Home's Secretary was trending across the UK on Twitter, with constitutional lawyers and ordinary citizens sharing clips of the Baroness's methodical demolition of Braverman's legal arguments. The immediate response from the legal community was one of professional admiration and relief. The Law Society issued a statement within hours. Baroness Hale's response today perfectly demonstrated why constitutional expertise matters in governance. Her systematic correction of misconceptions about judicial review and human rights law was a masterclass in constitutional education. Professor Mark Elliott of Cambridge University, one of Britain's leading constitutional scholars, tweeted, "What we witnessed today was the difference between serious constitutional scholarship and political rhetoric dressed up as legal argument." Lady Hale's response was devastating in its precision and authority. The Bar Council's chairman, Nick Vinell QC, was even more direct. Lady Hale's performance today reminded us why we have an independent judiciary and why constitutional principles cannot be subordinated to political convenience. Her dismantling of the Home Secretary's arguments was intellectually brilliant. Even conservative legal figures who disagreed with some of Lady Hale's past decisions were forced to acknowledge the superiority of her constitutional reasoning. Lord Sumption, a former Supreme Court justice known for his conservative views, told The Times, "While I may disagree with Lady Hale on some matters, her constitutional analysis today was unassailable. She demonstrated mastery of legal principle that was simply beyond the Home Secretary's capability to challenge. The contrast with reactions from political commentators was stark. Legal experts focused on Lady Hale's demonstration of constitutional expertise, while political commentators struggled to defend Braverman's obvious failure to understand basic constitutional principles. The Daily Telegraph, traditionally supportive of conservative politicians, was forced to acknowledge the intellectual mismatch. Whatever one's political views, it was clear that Lady Hale possessed a level of constitutional knowledge that the Home Secretary simply could not match. The exchange highlighted the importance of legal expertise in constitutional governance. Even the Daily Mail, which had previously been critical of Lady Hale's judicial decisions, ran a piece titled, "When Legal Brilliance Meets Political Posturing," that grudgingly acknowledged her intellectual dominance during the hearing. Social media exploded with clips and analysis of the confrontation. Legal Twitter was filled with law professors and practicing barristers sharing their favorite moments from Lady Hale's systematic takedown. The clip of Braverman's stammering response to questions about the Rwanda judgment was viewed over 2 million times within the first 24 hours. University law departments across the country began incorporating clips from the hearing into their constitutional law courses. Oxford Law faculty announced that Lady Hale's responses would be used as teaching materials for courses on judicial review and constitutional principles. The Inns of Court, the ancient institutions that govern the bar, issued a joint statement, praising Lady Hale's exemplary demonstration of how constitutional principles should be articulated and defended in public discourse.
The professional implications for Braverman were severe and immediate. Legal commentators noted that her fundamental errors weren't minor mistakes that anyone could make. They were basic failures of constitutional understanding that suggested
either incompetence or willful misrepresentation of legal principles. Within 48 hours of the hearing, a group of over 200 barristers published an open letter calling for the Home Secretary to undergo constitutional law training before making further public statements about judicial review and human rights law. The letter, signed by QCs and senior barristers from across the political spectrum, was unprecedented in its direct criticism of a serving law officer. The Constitutional Law Association issued a detailed analysis of Braverman's errors, documenting each misstatement and providing correct constitutional analysis. The document became required reading in law schools and was cited by opposition politicians as evidence of the government's constitutional incompetence. Conservative MPs privately acknowledged that Braverman's performance had been embarrassing for the party. Several backbench MPs told journalists that they were concerned about having a Home Secretary who appeared to misunderstand basic constitutional principles. The damage to conservative constitutional strategy was also significant. For years, conservative politicians had been attacking judicial review and human rights law as obstacles to effective governance. Lady Hale's performance had not only refuted those attacks, but had demonstrated that they were based on fundamental misunderstandings of constitutional law. The hearing fundamentally changed how Braverman was perceived by both the legal establishment and informed political observers. Before the confrontation, she had been seen as an aggressive but potentially serious conservative voice on constitutional issues. After Lady Hale's systematic demolition of her arguments, she was viewed as someone who used constitutional rhetoric without understanding constitutional principles. Legal betting markets immediately reflected Braverman's damaged reputation. Lawyers began predicting that her constitutional arguments would carry less weight in future court cases, given her demonstrated lack of understanding of constitutional principles. The impact on government legal strategy was also significant. Civil servants in the government legal department reportedly expressed concerns about defending policies that had been articulated by ministers who didn't understand the constitutional principles involved. Several senior government lawyers were said to be considering their positions, concerned that their professional reputations could be damaged by association with constitutionally illiterate policy arguments. For Lady Hale, the confrontation enhanced her already formidable reputation. As Britain's foremost constitutional expert, legal commentators noted that her systematic destruction of Braverman's arguments demonstrated not just intellectual superiority, but a deep commitment to constitutional education and public understanding of legal principles. The former Supreme Court president received hundreds of messages from lawyers, judges, and legal academics praising her performance. The Master of the Rolls, Sir Geoffrey Voss, publicly commended her outstanding contribution to constitutional discourse and public legal education. International legal observers also took notice of Lady Hale's performance. Constitutional courts across the Commonwealth praised her articulation of judicial review principles and her defense of constitutional governance. The Supreme Court of Canada invited Lady Hale to deliver the annual Boralaskan Lecture on Constitutional Law, specifically citing her hearing performance as evidence of her continued leadership in constitutional scholarship. The hearing became required viewing in law schools, not just in Britain, but across the English-speaking world. Harvard Law School announced that Lady Hale's responses would be incorporated into their comparative constitutional law curriculum. 6 months after the hearing, Suella Braverman's credibility on constitutional issues was permanently damaged. Her subsequent statements about judicial review and human rights law were regularly fact-checked against basic constitutional principles, with legal commentators frequently noting her previous errors. The Home Secretary's speaking fees for legal conferences plummeted and several legal organizations cancelled planned appearances. Her reputation as a serious legal thinker had been destroyed by someone who simply knew constitutional law better than she did. Meanwhile, Lady Hale's influence continued to grow. Universities competed to offer her visiting professorships. Legal publishers sought her contributions to constitutional law texts, and judges across the Commonwealth sought her guidance on complex constitutional questions. The hearing proved that in British democracy, constitutional expertise still matters. Political rhetoric and media manipulation could only go so far when confronted with genuine constitutional knowledge and judicial wisdom. Lady Hale's systematic destruction of Braverman's arguments became a case study in how constitutional competence exposes political incompetence, how legal scholarship defeats empty rhetoric, and how genuine expertise triumphs over manufactured controversy. The confrontation also highlighted the importance of having genuine constitutional experts in positions of authority rather than politicians who mistake sound bites for legal analysis. Lady Hale's performance showed why constitutional governance requires people who understand constitutional principles rather than those who exploit constitutional ignorance for political gain. For the British constitutional system, the hearing was a powerful reminder that the rule of law depends on having people in positions of authority who understand and respect constitutional principles. Lady Hale's performance under questioning demonstrated exactly the kind of constitutional expertise and intellectual rigor that British governance requires. The lasting impact of Lady Hale's masterful handling of Suella Braverman's constitutional misconceptions will be felt for years to come. Law students will study her approach, constitutional lawyers will emulate her methods, and future law officers will aspire to demonstrate the same level of constitutional expertise and intellectual honesty. Most importantly, the British people witnessed firsthand what real constitutional expertise looks like when it confronts political posturing. Lady Hale's performance reminded everyone why constitutional governance requires genuine legal scholars rather than politicians who mistake political rhetoric for constitutional analysis. The hearing demonstrated that constitutional principles are not political tools to be manipulated for partisan advantage, but fundamental foundations of democratic governance that require serious study and genuine understanding. Lady Hale's intellectual dominance showed that constitutional law is too important to be left to politicians who don't understand it. For anyone concerned about the quality of constitutional governance in Britain, Lady Hale's performance provided hope that constitutional expertise still matters, and that empty political rhetoric cannot survive confrontation with genuine legal scholarship. If you want to see more moments where constitutional expertise triumphs over political opportunism, make sure to subscribe and hit that notification bell. Our constitutional system works best when we have genuine experts like Lady Hale defending legal principles against political attack, and we need to recognize and celebrate intellectual honesty over partisan manipulation. What other examples have you seen where legal expertise defeated political rhetoric? Let us know in the comments below, and don't forget to share this story with anyone who appreciates the importance of having real constitutional scholars protecting our democratic institutions.